to Chicago has just blown apart Prince Harry's UK security lies.
But apparently for me, that doesn't matter.
I'm almost speechless.
Like, I tried so hard.
This is a total disaster for Prince Harry and his ongoing claim against Ravik in the United Kingdom.
On the morning of Saturday, May 2nd, 2026, a woman in a beige turtleneck slipped quietly into a pew at Holy Name Cathedral on North Wabash Avenue in central Chicago. She smiled at the congregation. She posed for a quick photograph with a working television reporter sitting beside her. The reporter posted that photograph to X within hours. And then, once the story had been picked up by the mainstream media, she deleted it.
However, like everything with Meghan Markle, this event was immediately shrouded in bizarre controversy because Natalie Martinez, once the story had been picked up with the mainstream.
The woman in the beige turtleneck was Meghan Markle, and what she did that Saturday morning did not just generate a news cycle. It dismantled, in a single weekend, the most expensive legal case the Sussex family has ever fought. A case that cost Prince Harry close to £1.5 million. A case built on the argument, stated explicitly in court filings and repeated on camera by Harry himself, that the United Kingdom is too dangerous for his wife and children without the permanent protection of armed British police. The argument that had consumed years of legal proceedings, that had been heard by the High Court and then the Court of Appeal, that had involved King's Counsel standing before senior judges,
claiming that they need guaranteed constant security protection from the British taxpayer because they are so under threat in the United Kingdom, and it is just impossible given how famous they are and given their royal role for them to travel around just like Meghan did.
Harry walked outside,
and invoking al-Qaeda threats and arguments about the safety of children, was undone not by a counter-argument or a court ruling or a journalist investigation. It was undone by a photograph. One photograph, taken by a television reporter on her phone, in a cathedral pew, in a city whose murder rate is 13 times higher than the city Harry says is too dangerous for his family. To understand why that Saturday morning in Chicago matters as much as it does, you need to understand what happened exactly 1 year and 1 day before it. On May 2nd, 2025, the Court of Appeal of England and Wales delivered its judgment in Harry's security case. 3 judges, including the Master of the Rolls, Sir Geoffrey Voss, the second most senior judge in England and Wales, listened to Harry's arguments, reviewed the documents, and dismissed the appeal unanimously. The word Sir Geoffrey Voss used to describe the government's bespoke security approach was not unreasonable. It was not defensible. The word he used was sensible. Harry walked out of that courthouse.
She's realised she is just normal, but then it's like, what happened in terms of this local television celebrity posting the picture? Then the moment it's picked up by People magazine, Britney, she deletes it. Well, I'm sorry. I'm not born yesterday. We know the stunts Sunshine Sachs, Meghan's PR company, pulls. It's like...
And sat in front of a BBC camera the same afternoon. He looked directly into the lens and said the words that have now become one of the most consequential self-contradictions in the history of modern royal affairs. He said he could not see a world in which he would be bringing his wife and children back to the United Kingdom. He said it was really quite sad that he would not be able to show his children his homeland. That was May 2nd, 2025. 12 months later, to the day, his wife was in a Chicago cathedral, alone, with 1 private bodyguard, and no perimeter. To appreciate the full weight of that contradiction, you need to understand the legal architecture that Harry's team had spent years constructing. The body at the center of the dispute is Ravik, the Royal and VIP Executive Committee, the body that determines which public figures receive state-funded protection in the United Kingdom. When Harry and Meghan stepped back from royal duties in February of 2020, Ravik convened and made a decision. Metropolitan Police protection would be withdrawn from March 31st of that year. Future UK visits would be handled on a bespoke basis, assessed case by case, with 30 days notice required. Harry's response to that decision was to sue. He filed a judicial review claim in September of 2021. By December of 2023, he had submitted a written statement to the High Court that included a passage that has since become central to the entire argument. He wrote that the United Kingdom is central to the heritage of his children and a place he wants them to feel at home as much as where they currently live in the United States. He wrote that this cannot happen if it is not possible to keep them safe when they are on UK soil. Not safe on UK soil. That phrase, and that framing, became the spine of every argument his legal team made across 4 years of proceedings. At the Court of Appeal hearing in April of 2025, Harry's King's Counsel, Shahid Fatima, stood before the judges and laid out the stakes in the starkest possible language. She told the court that Al-Qaeda had called for Harry to be targeted. She referenced a published Al-Qaeda document that she argued made the threat specific and credible. She used the phrases safety, security, and life are at stake. That was the case. That was the argument. 3 judges heard it, read the supporting documents, and on May 2nd, 2025, they said it did not hold up. Ravek's bespoke approach was sensible. The appeal was dismissed. The case that had consumed years of Harry's energy and close to £1.5 million of his money was over. And then, 12 months later, his wife flew to Chicago. People magazine, which has functioned for years as the Sussex family's most reliable and sympathetic media outlet, heralded the trip in terms that were clearly drawn from a briefing by the Sussex team. The story described Meghan making a rare solo trip to Chicago for her godson's first communion. It specified that she arrived early to Holy Name Cathedral without any special accommodations. It noted that she sat in the pews alongside other families.
Local television celebrity posting the picture, then the moment it's picked up by People magazine, Britney, she deletes it. Well, I'm sorry. I'm not born yesterday. We know the stunts Sunshine Sachs, Meghan's PR company, pulls. It's like, let's get this...
It mentioned that the only distinguishing feature of her attendance was the presence of a personal bodyguard. Singular. One bodyguard. Harry was not there. The children were not there. The trip was solo. And the security model in place was precisely the model that Harry's legal team had spent 4 years arguing was dangerously inadequate for exactly this kind of public appearance by a member of his family. The People's story is worth examining in detail because it contains a detail that has been almost entirely ignored by the mainstream media coverage of this trip. The godson, according to the People's source, is the son of one of Meghan's best friends from her time at Northwestern University, where she studied from 1999 to 2003. The friend has not been named. The godson has not been named. The child's parents have not been named. No independent verification of the relationship has been offered by any outlet other than People, which received its information directly from a Sussex team briefing. That is worth noting on its own terms. The entire premise of the trip, the warm human reason for a solo journey to Chicago that happened to be documented by a local television reporter and amplified by People magazine within hours, rests entirely on an anonymous source who spoke to a publication with a documented history of receiving and publishing Sussex-approved narratives. The friend is real, presumably. The child is real, presumably. But the framing of the story, the choice to brief it to People, the timing of the photo's appearance and deletion, and the speed with which the narrative was packaged and distributed, all follow a pattern that anyone who has been watching the Sussex communications operation for the past 5 years will recognize immediately. And the claim that Meghan is the godmother to this child raises a question that anyone with a passing familiarity with Catholic canon law would immediately recognize. Canon 874 of the Code of Canon Law sets out the requirements for who may serve as a godparent at a Roman Catholic baptism. The requirements include being a Catholic who has been confirmed and who has already received the Eucharist, and who leads a life of faith in keeping with the function to be taken on. A baptized non-Catholic Christian is not to participate except together with a Catholic sponsor, and then only as a witness of the baptism. A Christian witness, not a godmother. Meghan Markle was baptized for the first time in her life at the age of 36 on March 6, 2018, in the chapel of St. James's Palace by the Archbishop of Canterbury, Justin Welby, into the Church of England, with water drawn from the River Jordan. The dates are on the public record. The officiating clergy is on the public record. She is not a Roman Catholic. She has never been received into the Roman Catholic Church. She became Anglican in the lead-up to her marriage to Harry, and by every available record, she remains Anglican. Catholic school attendance, and Meghan did attend Immaculate Heart in Los Angeles as a non-Catholic student, does not confer Catholic membership. It does not satisfy the canonical requirements for serving as a Roman Catholic godparent. So either the People's story is using the word godmother loosely, allowing it to do public relations, work that the actual canonical role cannot carry, or there is a diocesan dispensation that no outlet has bothered to request or confirm. Neither of those possibilities reflects well on the story that was carefully briefed to a friendly outlet to generate sympathetic coverage of a solo weekend trip. The pattern is the same one that has appeared repeatedly across the Sussex communications operation. Choose the word that makes the story warm. Trust that nobody will check. This time, People checked. But the canonical question, significant as it is ultimately a secondary consideration compared to what the Chicago weekend does to the security argument. Because the contradiction here is not subtle. It is not a matter of interpretation or legal nuance. It is direct, documented, and dated to the same calendar day 12 months apart. Let us go through it systematically, because every barrister who will ever oppose the Sussex family in a future UK legal proceeding now has this material waiting in their disclosure bundle. Harry's legal filings argued that private security cannot replicate state-level protection. The specific claim was that the kind of armed police presence that Ravek provides is categorically different from, and superior to, any privately arranged security model. On the Saturday in question, Meghan walked into a publicly listed, centrally located cathedral in Chicago with one private bodyguard and no perimeter, no advance team, no armed escort, no state-level protection of any kind. That is the model her husband's lawyers told the Court of Appeal was inadequate to keep her safe. Harry's King's Counsel told the Court of Appeal that safety, security, and life are at stake. If those words were accurate, if the threat level is genuinely what the legal submissions described, then a solo flight to a large American city, attendance at a public Catholic Mass with 1,100 unfiltered congregants, and a single private bodyguard as the only security measure, represents a decision that no person operating under a genuine Al-Qaeda-level threat assessment would ever make. Either the threat is real and the behavior is inexplicable, or the behavior is rational and the threat was overstated. Those are the only two options. The court already made its choice. Sir Geoffrey Voss called Ravek's approach sensible. Meghan's conduct in Chicago has now made the same call through her own actions. Harry told the BBC on May 2nd of 2025 that he cannot see a world in which he would bring his wife and children back to the United Kingdom. 1 year later, his wife voluntarily flew into Chicago, a city whose homicide rate is approximately 13 times higher than London's. In 2025, Chicago recorded 460 homicides, the lowest figure in 60 years, and a genuine improvement that the city deserves credit for. But even at a 60-year low, the numbers are stark. England and Wales, with a combined population of 60 million people, recorded 522 homicides in the same period. Chicago, with a population of 2.7 million, came within striking distance of the same total. One mid-sized American city, representing roughly 4% of England and Wales's population, produced almost as many murders as the entire combined jurisdiction. The per capita probability of being a homicide victim in Chicago is roughly 18 times higher than in the United Kingdom. Harry said his wife could not come home because the UK was not safe enough. She chose somewhere 18 times more dangerous instead. She did so voluntarily. She did so without armed police. She did so with one private bodyguard. She did so in a public venue with 1,100 people she did not know. And she did so on the same calendar date, 1 year later, that Harry had stood outside a London courthouse and told the world the UK was too dangerous for her to visit. The symmetry of those two moments, the same date, 1 year apart, one in London and one in Chicago, is not something that any communications team can spin into a coherent narrative. There is no version of this that makes both things simultaneously true. Either the UK is genuinely dangerous in the way the legal filings claimed, in which case Chicago is incomprehensibly reckless, or Chicago is a reasonable choice for a solo weekend trip with minimal security, in which case the UK was never as dangerous as the legal filings claimed. Sir Geoffrey Voss chose option 2 in May of 2025. Meghan's own behavior has now chosen the same option, 12 months later, in a beige turtleneck, without apparently realizing what she was confirming. Harry's legal team filed evidence of a New York paparazzi car chase as proof that private security arrangements failed the Sussex family in the United States. They used that incident to argue for the necessity of state-level protection. The Chicago trip involved the same private security model that produced the New York incident. No upgrade, no enhanced protocols, no additional personnel. And yet on this occasion, the model that Harry's lawyers described as dangerously inadequate produced no incident of any kind. The contradiction between the legal argument and the lived reality is complete. Harry said the Ravek bespoke arrangement, which would have required 30 days' notice and a case-by-case assessment, was too dangerous and too uncertain to allow the family to travel safely in the United Kingdom. Meghan's own source, briefed to People magazine, confirmed that she had no special arrangements at all in Chicago. She arrived at a public venue in a major American city without notification, without advanced security assessment, and without any of the procedural safeguards that Harry's team told the court were the minimum necessary to protect his family. The dangerous bespoke model, by his own wife's behavior, turns out to be more careful than what she actually used on her solo weekend trip. The children. This is perhaps the starkest element of the entire contradiction. Harry and his legal team have argued for years that Archie and Lilibet cannot safely visit the United Kingdom because the security arrangements are insufficient. The children have not been to the United Kingdom since June of 2022. The stated reason is that their father cannot ensure their safety on British soil. On the weekend in question, their mother flew alone to Chicago, 2,000 miles from Montecito, while Archie and Lilibet remained at home. The logic that governs which environments are considered safe for which members of the Sussex family requires an explanation that neither Harry nor his team has provided. Their mother is safe enough to be in Chicago without armed police. Their father cannot bring them to a country with a homicide rate 18 times lower than the city she chose. Make that argument hold together. It does not. The broader context of the week in which this happened makes the Chicago trip even more revealing. The same week that Meghan was photographed in a Chicago cathedral, the Met Gala took place in New York. She was not invited. Prince Eugenie, who was pregnant with her third child, was there. Archie turned 7 years old. Buckingham Palace held its first garden party of the season, hosted by the king. Thomas Markle, Meghan's estranged father, was quietly back in the United States managing a prosthetic leg fitting, getting on with his life without fanfare or press coverage. The as-ever brand was in the news for reasons related to chocolate price increases rather than commercial momentum. That was the week Meghan chose for her Chicago trip. That was the news cycle she walked into. Not just a cathedral, the whole surrounding picture, and every element of it. The missing Met Gala invitation, the palace garden party she was not part of, the father she has not spoken to in years, the brand that continues to struggle for traction. All of it forms the backdrop against which a solo trip to Chicago with one bodyguard and a People magazine briefing needs to be understood. This was not simply a godmother attending a first communion. This was a communications exercise inserted into a difficult week, designed to generate warm human coverage at a moment when the news cycle was running against her. It generated the coverage. It also generated the contradiction. And the contradiction, unlike the coverage, will not fade when the next news cycle arrives. It is now part of the permanent record. One beige turtleneck, one cathedral, one photograph, one date, May 2nd, 2026. Exactly 1 year after the Court of Appeal said the case was over. The timing is either an extraordinary coincidence or an indication of how little the Sussex communications operation understood about the implications of what they were doing. Either way, the record speaks for itself, and it will keep speaking for as long as anyone wants to listen. A Supreme Court permission application, a new claim against Ravek under a different government, a civil proceeding of any kind involving the Sussex security question. Picture the barrister on the opposing side receiving their instructions. They are handed two pieces of material. The first is the BBC footage from May 2nd, 2025. Harry looking into the camera, saying clearly and without qualification that he cannot see a world in which he would bring his wife and children back to the UK because it is not safe. The second is the photograph from Holy Name Cathedral, Chicago, May 2nd, 2026. Meghan Markle in a beige turtleneck, smiling at a television reporter's phone camera. One private bodyguard, 1,100 congregants, no perimeter, in a city whose homicide rate is 13 times higher than London's. That barrister does not need a closing argument. The two pieces of material, placed side by side, dated to the same calendar day 1 year apart, are the closing argument. The case is not just lost. It was always lost. The behavior simply took 12 months to confirm it in a form that cannot be spun or reframed or denied. Tom Bauer has been making a version of this argument since his first Meghan biography, Revenge, in 2022, and reinforced it in Betrayal in 2026. His thesis, stated plainly across both books and in numerous interviews, is that the Sussex security narrative was never principally about genuine fear. It was about leverage. It was about maintaining a hand on the British institutional door and demanding that it open on Sussex terms and at Sussex convenience. It was about the ability to say to the palace and to the public that the family's absence from the United Kingdom is the fault of the institution rather than a consequence of the decisions Harry and Meghan themselves made. The security case was the mechanism through which that argument was formalized and given legal weight. Bauer described it in terms that his critics called too harsh at the time. He said the case was about embarrassing the king, about making problems for the family, about Harry wanting to demonstrate that he remained someone who could create significant difficulties for the institution he had left, about emotional blackmail, the implicit message that the grandchildren would be kept from their grandfather unless the security demands were met on Harry's terms. Those characterizations were disputed when they first appeared in print. They are considerably less disputed now. What happened in Chicago on May 2nd, 2026, did not just weaken the security argument. It broke it. And it broke it not because of anything a court said or a journalist wrote or a critic argued. It broke it because of what Meghan herself chose to do on a Saturday morning, in a beige turtleneck, in a cathedral on North Wabash Avenue. She chose it. She flew there. She sat in that pew. She smiled for that photograph. And in doing so, she placed on the public record a piece of evidence that every future legal opponent of the Sussex family will have waiting in their preparation materials, stamped with a date that makes the irony impossible to miss, and carrying the weight of a contradiction that neither Harry nor anyone on his team will ever be able to adequately explain away. The receipts, as observers who have been following this story for years have consistently put it, were always going to arrive eventually. The archives were always going to be searchable. The court papers were always going to be on the public record. The BBC footage was always going to be there, dated and time-stamped. And the photograph from Holy Name Cathedral was always going to be dated to exactly 1 year after the day Harry told the world his wife could not safely come home. Every element of the Chicago weekend, the solo travel, the single bodyguard, the public venue, the uncontrolled crowd of 1,100 people, the television reporter in the next pew, the People magazine briefing, the canonical questions about the godmother role, and above all the date, points back to the same conclusion that 3 Court of Appeal judges reached 12 months earlier. The case was not what it claimed to be. The conduct of the woman at its center has now confirmed it beyond any reasonable dispute. And the next lawyer who has to face this material in a courtroom will have everything they need waiting for them, free of charge, in the public record. 1 beige turtleneck, 1 cathedral, 1 photograph, 1 date. The rest writes itself.